We're joined now by JN Gupta, former Executive Director of SEBI. Thanks, Mr. Gupta, very much for joining us. This is my summary of the judgment, which, I've been going through and I've also been anchoring, so multitasking. But number one, it's a clean sheet for the Adani Group. Number two, the court has entirely endorsed the investigation, role and functioning of the Securities and Exchange Board of India. And number three, has made it again clear that small investors in India need to be protected. Would you say that these are the three key points?
I would say there are a couple of more key points that I would say to be done. First, let me see about the three key points that you said. As far as the Adani Group is concerned, they have gone a clean sheet. That is there, no problem. But the best thing that has come out of the judgment is it has reinforced SEBI's capability, SEBI's domain, and Supreme Court has said that if it is in the domain of SEBI, no other investigative agency should override the SEBI's capability or knowledge about the market. So it is a time for SEBI to celebrate this judgment. Third, the expert committee recommendations, SEBI will give a recommendation and SEBI will see what can be done. But what I want to tell very simply is that look at what happened post-Hindenburg report. In ordinary circumstances, Hindenburg report would have come and gone. But what was given impetus to the Hindenburg report or its fallout or its importance was by our own people, our politicians, our PIL filers, all those people gave a weightage. And what happened to that? Based on that, the market fell very badly. And as we all know, those investors who did not have patience or who had borrowed money or whatever money they would have done, they panicked and they sold out. As a result, they lost. Now the question comes, and the Supreme Court has asked how to protect such investors against this type of loss. Now SEBI cannot protect any investor for a loss if it is caused by a panic which is created by some people, unless until we include all such actions of people under prevention of fraudulent and unfair trading practice, which unfortunately at present such people are not included. Because people went to the Supreme Court on the basis of a report whose credibility was not established. And they thought that that report contained all the gospel truth. Why they went, what they did, what intention they had, it is not me to discuss because I will have my opinion on that. But the fact is that they went with some motive. And that motive is the reason based on which the market fell and the investors suffered. Right. How to compensate and whether these people who went for the PIL should compensate the investor, it is a matter to be decided by Supreme Court. I cannot decide. Right. But one more thing is that the Supreme Court should in future impose costs and heavy costs on such litigators who not only waste Supreme Court time but also cause harm to general public. And lastly, I would say that there were statements made by LIC डूब जाएगा, State Bank डूब जाएगा. All these people cause tremendous harm to the institutions. And whether they could be sued for some wrongdoing, I do not know. But there has to be some responsibility on the litigators also.